I'm Greg Dell with attorneys Dell and Schaefer, and I'm here with disability attorney Stephen Jessup, and we're going to talk about disability insurance claims against MetLife. Specifically, we're going to talk about short-term and long-term disability claims, although whether it's short or long, it's basically the same approach. And we're going to go through an overview because we have specific videos already that we've done where we talk about applying appeals and lawsuits, but this is to touch on those things and also give our view about what we think of MetLife as a disability insurance company, and also some of the things that are concerning to us that we see in a lot of their disability policies. So from the outset, let's talk about, from your experience of handling hundreds of MetLife disability claims and speaking to hundreds of claimants nationwide, what's your view of MetLife as one of the 40 disability insurance companies?
I think MetLife is probably up there with, the Cignas of the world, the Prudentials. There's a large volume of cases with it, even though it does seem that there's not as many as there used to be with them. The most interesting thing I find that really kind of dictates how their claims process is going to go is the language of their policies. Their policies have a lot more in the way of restrictions, limitations for certain conditions. So they will set you up from the get-go to try to pigeonhole your specific condition into one of these 24-month limitations, or sometimes it's even only 12, as a way to set you up for an early exit denial, if you will.
Okay, we'll get into some of those details that you touched on, but what do you think about the quality of the review of MetLife versus some of the other larger companies? I didn't say it, but MetLife's one of the top 5 largest group disability insurance providers, meaning employer-provided policies. But where do you see the quality of their review when you get a MetLife denial compared to many of the other companies we see?
I would say the quality of their review is no different than any of the top 5 in that your initial denial, they're probably going to go easy on it in the sense that they're not going to use doctors. A lot of times it's nurses, internal, case managers, stuff like that. You see a lot of denials where there aren't medical doctors on it, almost as if they're trying to see if the person is going to bother appealing, what they're going to do, and then only at that point do they really try to build up a strong case against you. So you can expect early on, you may be sending all your information, your doctors, all this and that. And on an ERISA group disability policy, they may just kick it over to one of their nurses to render a medical opinion that may be, rubber stamped by an on-site physician.
So basically, in other words, you're saying that the initial denials are usually garbage, not done thoroughly, not detailed. But the reason they're doing that is because when the courts review a claim denial, and after you've done an appeal, and then you have to file a lawsuit, the courts are required to look at the quality of what was done on appeal and not necessarily what was initially done. So there really is not a big incentive for MetLife to initially do this full detailed review and then send it to you when they know that they can wait and see what you send them and then try to attack your appeal. Now, fortunately, the law has changed recently in the last year, where it used to be on appeal, we would send them information, they would review it with their doctors, and then we would never have an opportunity to respond to that again. However, the law has changed now where whatever they do on appeal, if they do a medical review, they have to give us the opportunity to review that again. So that's a positive thing, but it could also make it more difficult when we get into discussing the standard review, whether it's arbitrary and capricious or de novo, once a lawsuit's been filed. So let's talk now about the appeals. And the appeals come after a claim has been denied. ERISA requires you to file an appeal with MetLife because that's the law. You can't just go ahead and sue them because ERISA doesn't allow for that. So when you get involved in an appeal, what's the 2 or 3 most important things that you do in order to try to win the appeal?
First and foremost, it's all going to be driven by the medical condition that's disabling. That's always going to be the most important. And from that umbrella, you're going to take a look at your medical records, what the testing shows, what the opinions of the doctors are. And then also, what stage are we being denied at? Are you being denied under an initial own occupation period where MetLife is determining can you perform the material and substantial duties of your regular occupation, or under that any occupation standard where they're looking at some other alternate occupation? So we got to look at that aspect of it. And then, like I alluded to earlier with MetLife, then we're looking at the policy language. Most medical conditions, it seems, that we would typically see, whether it be pain-based or mental health-based, MetLife has a 24-month limitation. So it's workarounds on those. Specifically, if you are suffering from any type of chronic pain, herniated discs, fibromyalgia, rheumatoid arthritis, some of these certain various different things, there's ways that they can limit your policy to 24 months. There's exceptions to that. So say someone contacts us, there's a bad back, herniations, they can't work. Well, if there's no evidence of radiculopathies, MetLife could say, well, yeah, we think you can't work, but our policy says we only have to pay you for 24 months. So there's an added layer with MetLife that you see more so than in certain other carriers, where you have to really you could prove this person is no ways capable of working, but their policy language may be that they don't even have to necessarily consider that if it's going to be a limited condition. So medical is always the biggest. If you don't have medical support, you really don't have a leg to stand on. And then taking that medical, looking how it's going to apply into the occupational definitions, and then marrying that up with the policy provisions themselves.
So you mentioned, obviously what you were discussing was what's called the musculoskeletal limitation, and basically what they're saying is that if you have a pain condition, something that you're disabled by pain, which most people are disabled by the pain because you can't focus and then you have cognitive difficulties, but what they're also saying is that if you have one of those conditions, then we're going to limit you to 24 months. And they're one of the few companies that does that. There are several other big ones that do it, but it's very common.
It's pretty much in every single policy, they're right.
In the MetLife policy. So we work to try to get objective evidence, and we have been very successful in getting, even with fibromyalgia claims, getting additional information that courts have considered objective evidence to get beyond that. So don't feel that there's no hope if you're stuck with one of those claims, and we'd like to work with you to try to get over that. The other thing I want to address is this definition of occupation, how you think you have an own occupation definition of disability, but you really don't in a MetLife policy, and why would that be?
So when they're describing what your pre-disability occupation is, you read your definition of disability, unable to perform the material and substantial duties of your regular occupation. But the definition of regular occupation means how it's performed in the national economy. Now, it's not how it's performed for your employer or at a specific location, but how it's generally done. So then what they will do, vocational rehabilitation specialists, they'll do reviews, they'll look at various Department of Labor standards for jobs, and they'll just take a real kind of basic idea of what your job is and apply, can you do that? It's a way for them to really minimize what someone may specifically be doing and just put it under that standard. So yes, it may be protecting you from being able to do your own job, but your own job is really left up to interpretation.
So when we get involved in handling an appeal, we'll work with either a vocational consultant, or we'll work with an expert in your field or someone else who had done your occupation. Plus we'll work with you to really dig deep into what you were doing to try to show that the way in which they're showing it's done in the national economy is not reasonable compared to the way that most people in the economy are doing it, because they often rely on ONET, Dictionary of Occupational Titles, which was things set in the 1930s, which has been revised up. Most recent was 1998, which is still a very long time ago, to try to look at how people do their jobs today. So,
and also too, sometimes they just interpret the jobs wrong. You see that, for example, sales jobs. There's a big difference between inside sales and outside sales, but they'll try to do it that way. And quite often, when you're looking at the claim file, you may see that the employer actually sent the wrong job description, or they had the wrong information on file, so making sure that's all in line as well.
So we encourage you to watch our video on the MetLife appeals, because we have a lot of good tips there that dive deeper into it, because we only scratched the surface here. The last topic I want to transition to is dealing with the lawsuits and MetLife lawsuits. We have, again, specific videos talking about standard of review, whether it's de novo, whether it's arbitrary and capricious. How do you feel that MetLife looks at a lawsuit, and how difficult can it be for a claimant to try to win benefits in a lawsuit?
Well, it's going to be depending especially on de novo or arbitrary and capricious. As a default, the vast majority of cases are going to be reviewed under an arbitrary and capricious. So MetLife is going to really look at this with an air of, they'll be cavalier about it. They'll say, well, in court, we just have to show that ultimately we provide a reasonable review, had a reasonable basis to deny the claim. And also for people to also understand, we've talked about this, ad nauseum in other videos, there's no live testimony in court. You don't get juries. It's just a federal judge reviewing a very limited amount of information in your claim file. It's a very, very cold, calculated way that the courts look at this. MetLife knows this. You know, they're going to be set up in reviewing your appeal to cross their T's and dot their I's to be able to show to a judge, based on all the case law that's come before it, we did enough to be considered reasonable in our review. You know, an interesting thing in really even taking into this and how MetLife's going to look at it, someone may have stumbled upon this video and they have a private policy they purchased on their own. MetLife stopped writing those policies. They stopped doing that, and they just focused solely on the group policies because A, the law's more favorable to them. They don't have to worry about large, you know, settlements against them for bad faith and punitive damages. They're making more money that way. So they saw this is the way that we can really, you know, maximize our profits. And it's because this area of the law is so good for them. And that's why they're so really strong in their denials and also the way that they approach litigation.
Right, and I also find when you say approach litigation that historically they are aggressive in their litigation, meaning that they have no issues prosecuting it as far as they need to. I mean, they went to the U.S. Supreme Court a few years ago in a case called MetLife v. Glenn, where they were dealing with conflict of interest because they're the payor and the administrator, and we tried to have a case that went to the Supreme Court where they would try to say, well, there's going to be de novo review if you're the payor and the administrator, and the Supreme Court didn't go for that, unfortunately. Yeah. That would have been a complete game changer, but that was MetLife at the forefront of fighting for these ERISA disability policies. So, you know, whether you're looking to apply for MetLife disability benefits or you have a claim that's recently been denied or you've exhausted all of your appeals, you need to file a lawsuit, feel free to give Stephen or myself a call. Any of our disability lawyers can help you. We're available to help you anywhere in the country. We're going to provide you with an initial consultation. We're going to need a copy of your policy, possibly your denial letter if you've been denied. If you've already filed your appeal, we need your final appeal denial letter. We'll review that right away and we'll let you know immediately whether or not we can help you. Now, most importantly, a lot of people ask us, do we charge any fees or costs, or how do we charge? And the answer is we don't charge any fees or costs unless we get benefits for you. So there's no risk whatsoever for you to speak with us. There's no risk moving forward in terms of working with us because we're vested in your claim. We want to get your benefits paid so that we can get you back to where you were, and in a worst case scenario, get you some kind of lump sum settlement so that you get something rather than nothing for your policy, which is extremely important because a lot of people unfortunately call and say, is this worth pursuing? Am I going to get nothing? And like I tell them, if we believe in your case and we take your case, we're going to get you some kind of offer. I mean, whether it's not going to be a reinstatement of benefits, but it may be 10% of your benefit, it may be 75% of your benefit, you know, value over the duration. So that's things that we'd like to discuss with you when you call us. So we appreciate you considering us, and we look forward to the opportunity to speak with you.